It's great to see a crowd so interested in mingling and talking, and a lot of interesting issues raised in panel 1. So we're going to get started now with panel 2 on religious liberty and the court. Our moderator, Steve Engel, is going to introduce the panelists, but first I'm going to kick us off by introducing Steve Engel. He's a partner in the D.C. and New York offices of Docket, where he handles a wide range of civil litigation matters, including administrative law, commercial litigation, constitutional law, and securities cases. He served formerly as the Assistant Attorney General of the Office of Legal Counsel in the Department of Justice, where he essentially played the role of Chief Counsel to the Attorney General and Principal Legal Advisor to the Executive Branch. Currently, he's a member of the Advisory Council on Rules for the U.S. Court of Appeals for the D.C. Circuit, and happily for Scalia Law School, he's an adjunct professor there teaching separation of powers, and along with Don McGahn, former White House counsel, and Paul Clement, former Solicitor General, who we will hear from soon, he's a distinguished practitioner in residence at the Gray Center. And then connection to our topic today, he and his partner at Docket, Mike McGinley, have also found time with everything else going on to work with students with the Notre Dame Religious Liberty Clinic in helping to file some amicus briefs in Shurtleff versus Boston and Kennedy versus Bremerton School District, 2 religious liberty cases before the court this term. So it should be a great discussion. We have a lot of leading litigators on the panel right now. And with that, let's get started.
Thank you, Jen. And thanks everybody for being here this morning. We have terrific turnout here. We have really an exceptional panel, and I look forward to talking about what's a pretty fundamental issue of religious liberty, and particularly at the court. The American commitment to religious liberty stands, and this is not an exaggeration, really at the foundation of our system of government. It's part of our mythos, for the Mayflower and the Pilgrims. It spread throughout the United States before there was a United States during the colonial era, found its way into the original Constitution, which prohibits religious tests for office, and of course, it found its way at least twice into the First Amendment with the Free Exercise Clause, the Establishment Clause, really 3 times if you think that the freedom of speech is so important to protecting religious expression as well as religious practice. Given this long-standing providence, you would think that we might all have figured out actually what this means. But the truth of it is that the guarantee of religious liberty has been hotly debated, contested, and litigated really throughout the Republic, and particularly in the courts over the last 50 years. And in recent years, we've seen the Supreme Court doubling and perhaps redoubling its interest in the issue. And every term, it seems, we have important religious liberty cases that the court is addressing, and this term is absolutely no exception. Now, in recent years, the questions of religious liberty have frequently arisen in cases where federal state governments adopt regulatory mandates that impose particular burdens on the free exercise of religion. When do our laws require that neutral, generally applicable mandates find exceptions to accommodate the sincere views of religious believers? We saw these cases arise frequently during the pandemic, where local governments' efforts to impose shutdown orders on businesses and the like would often prevent religious congregations from meeting. And we've seen a lot of that litigation in the context of vaccine mandates, where people with sincerely held religious beliefs are being required to get vaccinated. Now, and we've also seen this issue arise increasingly with respect to anti-discrimination laws that have defined government programs or seek to regulate private conduct in ways that threaten the longstanding and traditional religious views of many Americans. In addition to these kinds of cases that we've seen and are currently seeing at the court, the Supreme Court has also addressed religious liberty in cases where state and local governments have read the Constitution's commitment to religious neutrality, the prohibition against the establishment of religion, as requiring the adoption of measures that would threaten to push religious speakers outside the public square. Now, this term, the Supreme Court has a number of cases that address these issues, and as mentioned, we have truly outstanding panel to discuss them. Each of our panelists has done a considerable amount, not only of thinking, but actually litigating questions of religious liberty. And frankly, if I would do justice to their bios, we'd probably have very little time for discussion. So let me try to briefly introduce our panelists, which I'll do in the order in which they are speaking, and then we'll have a discussion among the panel itself and open questions to, what I'm sure will be kind of robust questions from the audience. So our first panelist speaking today is Erin Murphy. Erin is a partner at the Washington office of Kirkland & Ellis, where her practice focuses on Supreme Court and appellate litigation. Erin has argued 4 cases before the Supreme Court, and she's widely recognized as one of the foremost appellate advocates of her generation. Of particular note, Erin is now counsel representing the petitioner in Kennedy versus Bremerton School District, case currently pending before the Supreme Court, and one of which that I'm sure we'll discuss today. Now, Nat Lewin currently practices law with his daughter at Lewin & Lewin, but he is truly a legendary Washington lawyer who has been litigating in the trial and appellate matters for more than 55 years. Nat was involved in litigating these questions of religious liberty at the time of the Warren Court, among other. Nat was a founding partner of Miller Cassidy, which for many decades was one of the foremost boutique law firms in Washington, D.C., and really in the country, and now can claim not 1 but 2 Supreme Court justices, or at least shortly, as among its alumni, with both Justice Barrett and soon-to-be Justice Jackson. Nat served at DOJ himself during the Kennedy and Johnson administrations, and he has argued 28 times before the Supreme Court. Now, many of the cases that he's litigated have involved religious liberty, although as a former OLC guy, I have a soft spot for his bringing the case in Zivotofsky, which wound up vindicating, maybe not on his side, but a very important principle of presidential power. Now, our third panelist is Mark Rienzi. Again, I keep talking about these folks, and I keep saying how great they are, but I'm really not underselling anybody or overselling anybody here. Mark is the president and the CEO of the Becket Fund for Religious Liberty, an organization that for decades has been extraordinarily influential in defending and advancing the religious liberties of all people of all faiths in the federal courts. Becket has been counsel or amicus in many of the key cases before the Supreme Court, most recently winning in Fulton versus City of Philadelphia, a critical religious liberty case decided by the court just last term. In addition, I could go on, Hobby Lobby, Little Sisters of the Poor. Becket has been heavily involved in some of these critical cases in recent years. In addition to when he's not running the Becket, Mark teaches at the Catholic School of Law, the Columbus School of Law, and Harvard Law School. And so he seems to have more hours in the day than most of the rest of us. And finally, last but certainly not least, Mark Stern is here. Is the Chief Legal Officer of the American Jewish Committee, and he too has spent decades litigating and advocating for religious liberty and other issues, particularly on behalf of these issues that are central to the American Jewish community. Mark came to the AGC after 33 years at the American Jewish Congress, where he served as general counsel and acted as a co-executive director. He's authored numerous legal briefs, published many articles, and has participated in arguing 4 cases before the U.S. Supreme Court. So I may not have been as short and brief in describing the panelists as I promised, but it was difficult. So I'm very grateful to be here among them, and I look forward to hearing what they have to say. Now, let's start with Erin.
Great. Well, thanks, and it's wonderful to see so many people here. Excited to hear about the court's religious liberty docket. Per usual, over the past few years, this is yet another year where the court's got some good and important cases, most of which have not been resolved yet, but one that has. Before we kind of all, give you lots of insightful thoughts about the cases, I thought I'd take a little time to just tell folks a little bit about them. I'm sure some of you follow the court's docket very closely, but for those of you who don't, we'll just give a little bit of an overview of what the court is hearing this term that involves religious liberty. The court has 4 principal cases that involve religious liberty issues, and I'll start with Kennedy, just, because it's my case, so why not? So Kennedy versus Bremerton School District is a case we've been involved in for quite some time. I think our first trip up to the court was like 4 years ago at this point. But Joe Kennedy is a high school football coach, or was a high school football coach, and he believes his sincere religious beliefs that have never been questioned on sincerity front, that he should kneel and give thanks to God briefly after games, right? Kind of right after the conclusion of games, he just takes a knee, says a quiet 30-second prayer, and moves on with things. For a while, when he started as a coach, he just took a knee by himself and said his prayer. Over time, some students kind of saw what he was doing and asked what he was doing and said, can we join you? And he said, well, it's a free country. Do whatever you want. And students did start joining him. And eventually, over time, the practice kind of evolved into him actually using prayer in post-game speeches and joining students in some pre-game locker room prayers. For about 7 years, nobody cared about this or complained about this or thought it was a problem, but eventually, I think it was actually somebody from an opposing team's school that saw it and brought it to the district's attention and complained. The district then spoke with Kennedy and explained Establishment Clause concerns and the like, at which point he agreed to not use prayer in post-game talks to the students or in pre-game locker room talks or anything like that, but said, I think I should still be able to just take a knee and say a brief prayer quietly by myself. And I also think that if students choose of their own volition to do that when it's not part of any official post-game activities or anything, that's okay. And the district adamantly disagreed with that, insisted that he could not engage in any demonstrative religious activity while on duty and in view of students and the public. And ultimately, he declined to abide by the district's commands and ended up losing his job. So he brought suit, arguing that this violated both his free speech rights and his free exercise rights. And the case actually, he lost in the district court and the Ninth Circuit the first time around on free speech issues, and the case went to the Supreme Court. And some of you may recall, the first time we went up to the Supreme Court, they denied cert, saying the case was in an interlocutory posture and there were some facts to still be figured out. But 4 justices wrote kind of a rather remarkable 4-justice statement respecting the denial of certiorari, in which they said, just to be clear, we don't think the Ninth Circuit got this right. We're just not sure now is the time to get involved, and hopefully they'll get the message the next time around. They did not. The case went back down, and instead the Ninth Circuit doubled down on its earlier holdings and in fact expanded them. So what the lower courts held here is that when Coach Kennedy knelt to say a prayer, he was actually engaging in government speech that is not protected by the First Amendment at all. And then the Ninth Circuit went on to hold that even assuming it was private speech, the school district not only could, but in fact had to prohibit it to avoid violating the Establishment Clause. So we came back up to the Supreme Court, and lo and behold, this time they decided they should hear the case. So we will be up there in just a few weeks from now to argue the case in the last week of the court's term. And it really, it's a great and really interesting case because it truly presents kind of all three, as Steve was talking about, all 3 components of the First Amendment and how they interact and how we would say free speech, free exercise, and the Establishment Clause itself all work together to protect religious liberty. Obviously, you'd hear a little bit different story from the other side, but I'll spare you getting into the entire debate about who's got the best of the arguments here. But it should be a very interesting case to keep an eye on in the next few weeks. Probably the other kind of biggest case, I think, kind of most consequential case the court has on its docket is a case it heard a few months back, Carson v. Macon. This is a case in a line of cases the court has heard over the past decade involving questions of public aid to religious schools. So probably any of you remember the Trinity Lutheran case a few years back, where the court held that the Free Exercise Clause prohibited Missouri from excluding a religious daycare center from a grant program just because it was religious. And then a few years later, the court decided the Espinoza versus Montana case, where it held that the Free Exercise Clause prohibited a state from, the state that had a tuition assistance program, from barring private religious schools from participating in that program solely because they are religious. So from those cases, we basically got a rule from the court that the Free Exercise Clause prohibits the government from excluding otherwise eligible organizations from a public aid program just because they're religious. But the question the court reserved in both cases is whether it matters if the discrimination is on the basis of the religious status of the school or person or whatever it may be, versus if the money is going to be put to a particular religious use. And that distinction is kind of at the core of the Carson v. Macon case, which is really kind of about if you go beyond discriminating on the basis of religious status and say money can't be put toward religious use, is that somehow different? So this is another case that arises in the context of a tuition assistance program. The state of Maine has a program. There's a lot of school districts in Maine where there's not a public high school available. And so they have a program that says that if you're a student who has no designated public high school available to you, you can use tuition assistance that's provided to basically pick the private school, public or private school that you would like to go to. And they don't exclude religious schools from the program writ large, but they examine the schools and decide whether they provide a quote unquote secular education. And if they decide that there's sort of too much religion in the religious education that a religious school provides, then the school is excluded from being able to participate, and students are unable to put the money toward attending that school. So this program was challenged, and it was upheld by the First Circuit, basically relying on that distinction between status and use. The First Circuit said, this is okay because it's not about excluding a school on the basis of being religious. It's about the money going to something that's sort of too religious. The Supreme Court granted cert. This has been kind of a circuit split type question. So they granted cert to resolve that and heard argument. I think it was back in January. So this case really, I think, turns a lot on sort of the case from a while back, Locke v. Davey, in which the Supreme Court held, this was back in, I don't know, was that the 80s or the 90s? Somewhere around there. But held that the state of Washington could permissibly exclude from a tuition assistance program people participation in a devotional theology program. And really a lot of the question then becomes, is Locke just a case that was about a specific concern with money going to the specific idea of actually training people to be kind of in the business of devotional theology, or does it stand for a broader principle that you can really say money can't go to any religious use at all? So this is a really, I think it's a pretty important case that has implication. Maine's program is a little bit funny and a little bit sui generis as compared to a lot of other tuition programs, but I think the court has the potential to resolve a pretty important question there that's been kicking around up at the court for the past, really for the past decade. There's a couple other cases I'll briefly mention. One is Shurtleff, which is another case the court heard argument in a few months back, but we haven't heard a decision from yet. It's a case that I think really involves kind of viewpoint discrimination on the basis of religion, principally. So the city of Boston has 3 flagpoles in front of its government buildings, one of which flies the United States flag, one flies the state flag, and one flies the city flag. But they have a program where they allow private parties to ask to temporarily displace the city flag and put up their own flag. And they basically let everybody who has ever asked put their flag up, including flags that had religious symbols, had crosses. They kind of allowed anything. Kind of took all comers for a very long time. But then an applicant came along called Camp Constitution that's focused on kind of celebrating the nation's Judeo-Christian history. And they specifically put in their application that their flag was a Christian flag. And at that point, the city decided, nope, can't allow that. The flag is, by the city's own admission, essentially identical to flags that they have agreed to fly. And they basically said, if you hadn't told us it was a Christian flag, we would have just flown it. But you said it, and once you did, we became very concerned that this was going to be an Establishment Clause problem. So this too, is another case about kind of the idea that does the Establishment Clause really compel the rule that, even if all other speech is okay, somehow the government can't, even in what seems to be a public forum, allow for private speech, for private religious speech? It's a pretty subtle law that you can't. So I think it's a case that'll largely turn on kind of reiterating those public forum principles and the idea that even in a not entirely public forum, the government, the one thing they can't do is engage in viewpoint discrimination, including on the basis of religion. Finally, we have one case that the court has actually decided that involved religious liberty issues, and that is Ramirez versus Collier. This is a case in the death penalty context. Mr. Ramirez was sentenced by the state of Texas to execution, and he asked for his pastor to be able to lay hands on and pray over him at the moment of execution. Texas generally allows pastors and chaplains to be in the room at the moment of execution, but it said that it would cause both kind of safety concerns and other concerns to allow somebody to actually lay hands on someone during the execution and be able to pray over them. The court issued an opinion just a week or two ago in which it rejected Texas's arguments 8-1 and held that that this was all in a preliminary injunction posture, so they held that Mr. Ramirez was likely to succeed on his claims that Texas's refusal to allow his chaplain or his pastor to lay hands on him was impermissible. It's a case that arises under RLUIPA, not the First Amendment, but it's a strict scrutiny case. I think what was interesting to me in the case is the court went out of its way to actually say that pretty much every interest Texas asserted was a compelling interest and really resolved the case almost exclusively on the least restrictive means prong of strict scrutiny. And I think what really drove the decision was the fact that the federal government and some other states have allowed pastors and chaplains to engage in the practice that Texas was saying it can't permit. I think the court kind of looked at that and said, look, others have demonstrated that this is something that's workable. So, it seems unlikely that you're going to be able to say that something about Texas is so different that you can't figure out a way to accommodate this religious exercise. So I'll stop there and let other folks actually offer insightful thoughts about all the cases.
Thank you, Aaron. It's helpful to set the stage here. Our next speaker is Nat Lewin.
I'm up here at a podium, not sitting down, because, as you heard from the introduction, I'm accustomed to speaking at podiums before the Supreme Court. So it's appropriate for me to stand up before you, not sit down, but actually speak at a podium. I appreciate the very generous introduction that Steve has made, but as usual, he talked about the firm of Miller Cassidy. It was, in fact, Miller, Cassidy, LaRocca, and Lewin. And in fact, we will have 3 alumni on the Supreme Court because Justice Kavanaugh also worked for our firm. So it turns out that this 35-member little litigation firm will have 3 alumni on the Supreme Court. Now, he mentioned Miller Cassidy, and not Miller Cassidy, LaRocca, and Lewin, and I was frequently asked when I was with that firm, how come I was the last name on the firm? Why was it Miller, Cassidy, LaRocca, and Lewin? And I would explain to those who asked that they don't realize that most of my clients read from right to left. Now, why have I come here today? I can only tell you my family is hysterical over the fact that I'm here today. The newspapers today have the fact that Speaker Pelosi and Mayor Bowser have COVID. And I'm told if I come to this group and I see no mask really at anybody sitting at a table here, I'm jeopardizing myself and my family. I have in the briefcase over there wipes, tissues, all kinds of things that I was told I have to come prepared with. So it's all there. Why did I come? I came today because I think it's important to hear, for a group like this, to hear what may be a minority view. You've heard about how interested the Supreme Court is in religious liberty. I think that's phony. I think it's a cover-up. In fact, in terms of Ramirez versus Collier, I had a piece in Newsweek, which I think is supposed to be distributed here, headed, "Does the Supreme Court truly respect free exercise of religion?" And I submit to you that what the court has been doing with regard to religious liberty cases is only touching the fringes of religious liberty and not taking the cases and deciding the cases that really affect across the board Americans on religious liberty. Ramirez versus Collier, which is the last one that you heard about, is a perfect illustration. The court spent 63 pages of opinions, held an oral argument on a ridiculous religious liberty issue. Who really cares whether Mr. Ramirez, pastor, touches his hand as he's being executed? You can't tell me that that really deserves the attention of the Supreme Court of the United States. I feel sorry for him, maybe, but I certainly don't feel that the court should have spent the time in terms of viewing that as a religious liberty issue. And quite frankly, the other cases you've heard about, I think, are also petty cases. I think Coach Kennedy should be able to kneel at the 50-yard line and pray. But does that really affect what Americans in the United States who have religious convictions really, is it really important to them? The main First Amendment case, Carson or Macon, I did file an amicus brief in that case, but not because it is so important whether the one state in 50 that does not provide a publicly funded high school education for some of its schools should be able to exclude those who go to sectarian schools. It affects the state of Maine, and it affects a nice theory that's talked about by the First Circuit. But it's not really of national importance to people who have religious convictions. And that's true, it's certainly true of Shurtleff. I mean, these are picayune cases where the theory of the First Amendment can be discussed among justices and law school professors. What is important? What is important is, for example, whether Oregon versus Smith should be overruled. Justice Alito wrote an absolutely brilliant concurring opinion in the Fulton case. I think it was originally drafted as possibly being a majority opinion, but it didn't get a majority because Justice Barrett and Justice Kavanaugh, both alumni of my firm, thought, well, maybe it goes a little too far, although maybe it's right, but we don't know what we can substitute for it. But that is a case that should be overruled. The Supreme Court, that is a case that's important to people who have religious convictions in the United States. What else? Well, I did argue a case called TWA versus Hardison, which involves Seventh-day Adventists, Orthodox Jews, Christians who observe and have restrictions on work of various kinds. Cases come up all the time under an amendment to the Civil Rights Act of 1964 that says that you have to make accommodations to religious observance. And at a time when the Supreme Court was at the height of its Establishment Clause craze, it believed that the Establishment Clause prevented all kinds of things which it ultimately reversed. At that point, Justice Byron White wrote an opinion in a case in which I argued as amicus, saying that a clear statutory duty to make accommodations only meant that you have to make de minimis accommodations. The court kept saying in little opinions that Alito and Gorsuch, and at times even Roberts, and certainly Thomas joined, oh, we're going to overrule Hardison. The Solicitor General came into the Supreme Court and said, definitely overrule Hardison. And the Supreme Court denied certiorari on a couple of cases where it could have overruled Hardison. That would have made a difference to believing and religiously observant Americans. They didn't do that. And finally, in the limited time I have, let me just say one more case, which clearly the court has made fun of repeatedly, over and over and over again. A case called Lemon versus Kurtzman, which Warren Burger, when he was a young Chief Justice, was very proud of. But by the time he left, he didn't even want to cite it. If you look at the internal memos of the Supreme Court, and I have looked at them, I've used them in classes, it took Justice Brennan to tell Burger, put in Lemon and Kurtzman into your opinion, when he didn't want to do that already at that point. It's about time that Lemon and Kurtzman is overruled. Now, those are issues that the Supreme Court should decide if it's considering the religion clauses of the First Amendment. Thank you.
Thank you, Nat. And apologies to Miller, Cassidy, LaRocca, and Lewin, particularly, and to Justice Kavanaugh for having undersold his bio. And Deputy Attorneys General. No, I knew Justice Kavanaugh at Kirkland and Ellis, and that must have blurred my vision. Now, Mark Rienzi.
Great. Well, thank you, everybody, for being here. I have the unenviable task of going after Nat Lewin. The easy thing is I'm going to keep my seat because I'm going to leave the podium as Nat's spot, which seems appropriate. Let me try to talk about some of these cases, and let me pick up on something Nat said about kind of the old bad establishment clause from the era of Lemon, which I think has had a lot of bad effects, not just in the cases, and as Nat pointed out, even at the end of the Burger Court, and certainly now, you almost never see the Supreme Court rely on Lemon versus Kurtzman, right? It's a case that is there, that is a Supreme Court case that the lower courts feel obliged often to follow, but that the Supremes essentially almost never cite. I don't think they've cited it in almost 20 years now. And they've decided a lot of Establishment Clause cases. I think in some ways you can look at the three of the cases that are up this year. Shurtleff, the flag case, Carson, the school case in Maine, and the Coach Kennedy case. And I think you can kind of connect the dots of those as all places where the government's got a little bit of a 70s era Establishment Clause hangover, right? And that the ideas of Lemon, right? This idea of treating religion as as a bad or dangerous thing, or religion as asbestos. One of my colleagues sometimes says, but this idea that the government needs to be super careful about staying all the way away from religion. I think that's actually kind of what was going on with the government actions below in all of these cases. And if you ask me to predict by the time we get to June and we see these cases resolved, I think we're going to see the court saying to these governments in each of these circumstances, you simply can't exclude the activity simply because somebody is religious, right? So if you take the flag case, they run zillions of flags up the flagpole all the time. They literally never turned one down, right? Until somebody said out loud, well, that one's religious. And then they're like, no, we can't run that up the flagpole. Well, I don't think the Establishment Clause means that at all. That would be like saying on the National Mall, you can have all sorts of demonstrations, but not religious ones, right? Religion is allowed to participate, and religious people are allowed to participate in things that are generally available. And that flagpole is and was generally available, and excluding them just because they're religious is really just, again, that 70s era hangover, that older and debunked really view of the Establishment Clause ultimately affecting somebody's free exercise rights. And if you look at Carson, the same thing is going on, right? In Maine, they will let you take your public education funds to almost any school anywhere. You want to take it to a fancy prep school in New England, you can go. You want to take it to a fancy prep school in Paris, you can go. The thing you can't do is take it to a school that's actually exercising religion, right? So parents can choose all sorts of stuff they want. They just can't choose religion. And I think it's really just another example of the same problem of governments stuck in the old Lemon era way of thinking about the law, which, as Nat points out, is partially driven by the fact that the court hasn't actually gone all the way and overruled Lemon, right? So if the court doesn't overrule Lemon, then all of these government entities, all of these state, local, federal agencies, they were all brought up on the old way of thinking about the Establishment Clause, and they bake it into the way they do business. And the result of that is they exclude religious people and religious actions in all sorts of places. Same thing's going on with Coach Kennedy, right? If the guy kneels at the 50-yard line and says almost anything, right? If he says the refs stink, right? If he says vote for Trump or vote for Biden, there's no problem, right? The thing that makes the government say, oh, no, we got to fire the guy, is that he kneels and says the one thing that is unspeakable, which is he says something religious. Again, it's the government stuck with kind of the anti-religion view that Lemon fostered. The Supreme Court did a good job for a long time in peeling that back in the mid-'80s to mid-'90s. They did a lot of it. They've done a lot of it more recently. But what they haven't done is tell the whole world, stop relying on Lemon, right? And until they do, the lower courts will rely on Lemon, and governments will rely on that Lemon-style thinking to exclude people just because they're religious. So if you ask me to look at those cases and figure out, well, why did the court take those three, and what's the message the court's going to give? I'd predict it's a message of stop relying on Lemon so much. They're not going to overrule Lemon in any of these cases because Lemon itself isn't quite directly at stake in any of them. But I think the court can actually go a long way to ripping out the bad effects of Lemon if in these cases it tells the government to get out of that bad 70s era way of thinking about the Establishment Clause. Let me talk a little bit about the emergency docket and the Ramirez case and then the COVID cases that are all popping up on the emergency docket. The Ramirez case is interesting for another reason, which is the court was getting criticized a lot early in COVID. Right, let me back up 2 years now. It's too long, right? 2 years now. Early in COVID, the court was dealing with a lot of cases over the church and synagogue lockdown orders, right? Diocese of Brooklyn, Agudath Israel, those cases, right? And they got a lot of criticism for issuing important rulings on the emergency docket, right? The critics call it the shadow docket, as if it's like a scary, weird thing, right? Courts have to deal with emergencies. The Supreme Court has to deal with emergencies. It's nice that we can normally have the leisurely schedule of a Supreme Court case, that it gets granted and 8 or 10 months later, it gets decided. But some things need urgent answers, right? Sometimes someone's going to be put to death the next night. Sometimes people can't go to church or synagogue this weekend. And the court will step in and address something quickly. I don't think there's anything untoward about that. I think that's actually the court's duty to do. But the court got a lot of criticism for doing it, particularly in the Diocese of Brooklyn and Agudath Israel case, where they got rid of Governor Cuomo's lockdown orders in New York. I think as a result of that, we've seen the development of what you might call sort of a move from the emergency docket or the shadow docket to the critics to something like a rocket docket, which is what they did in Ramirez, right? So sometimes when they have weighty issues on an emergency timeline, they've now moved to saying, well, if we're going to get criticized for deciding it quickly on the emergency docket, let's just set it for merits briefing right away, and you can submit your merits briefs in a week or 10 days. And 10 days after that, we'll argue it, and then we'll issue a decision. They did that in Ramirez. They did that in the Texas abortion case, the SB 8 law down from Texas. And they did it in the federal COVID mandate cases. In all of those, the court did this, what I think is a relatively new, they at least hadn't been doing it recently, move of saying, let's take something from the emergency docket and let's put it on the merits docket and just go really fast. And Ramirez was a case where they did that. And I look at cases like Ramirez and Carson and Shurtleff and Kennedy. On one hand, they may not do the biggest things in religious liberty law, like knock down Employment Division versus Smith, or Lemon, or Hardison, and I agree with Nat, all three of them got to go. They're all bad decisions. They're all bad for religious liberty. But as I'm sure most of you have noticed over the past long time, the court doesn't always want to take it all in one big bite. And I think what the court tends to do in these smaller cases is they tend to advance the ball a little bit. Right? Ramirez reminds me of a case called Holt v. Hobbs from 6 or 7 years ago about whether a Muslim prisoner could grow a beard. On one hand, the particular issue isn't that important to too many people because most of us aren't in prison, right? But what the court does can be very important, right? So in Holt and again in Ramirez, we see the court making the following move. They say, well, I know you say a short beard would be really dangerous in Holt, or I know you say that having the preacher touch the guy during the execution would be really dangerous. But we can kind of look at what every other prison system is doing, and we've got, sadly to my mind, a long history of executing people in the country, right? We've killed a lot of people. We've got a lot of examples, and we can look around and we can see, has it actually been a problem? Has this actually interfered with any execution ever, right? Because the government can say we've got compelling interests, and they do this in the prison context, they do it in COVID, they do it in a lot of places. They can say we've got a compelling interest, but what I think the court is doing is it's using the application of the strict scrutiny test to tell the governments, yeah, but the facts matter, right? The facts actually matter. It actually matters if this has happened a million times and never been a problem. Because if it has, then in a constitution that protects religious liberty and where federal civil rights laws protect religious liberty, the government ought to have to protect religious liberty. That went on some in the COVID lockdown cases. I think we'll eventually get there in the COVID vaccine mandate cases. So let me say a couple words about those before I wrap up. On the COVID vaccine mandate cases, let me just point out a few interesting and I think promising things. One, on the federal power ones, the OSHA and the CMS ones. One, those cases did have religious exemptions built into them. In other words, they do allow employers to give religious exemptions. And Solicitor General Preligar said at oral argument that some people have deeply held religious objections and they should be entitled to exemptions. I didn't expect to hear that out of the Biden administration's mouth. It was good to hear. I take the point, and it's certainly true, that partially in light of Hardison and partially just in light of where we are as a culture, lots of employers are not giving their employees a fair shake on that, and I think that's a problem. But those mandates have religious exemptions in them. And actually, most states and most federal mandates do. A handful have not, and those have gotten to the Supreme Court's emergency docket. One in a case from Maine, one in a case that I've been working on called Dr. A, which is a case from New York. On the emergency docket, they've been able to get 3 votes, right? Justices Thomas, Gorsuch, and Alito would be willing to go right ahead and give the relief on the emergency docket, even though it gets criticized a lot. But I think in those vaccine cases, you're going to see a little bit of what ultimately happened with the lockdowns, right? Like with the lockdowns, what ultimately broke the back of the lockdowns? Well, it was, I think, the fact that ultimately the governments couldn't defend the idea that going to church or synagogue was more dangerous than going to a casino or going to the shopping mall or going anyplace else, right? All these other things that governments chose to allow in a world with contact tracing, right? Back when we used to contact trace, right? In a world with contact tracing, where the governments were actually trying to connect the dots of every spread of COVID ever, right? You just couldn't actually maintain the argument that church or synagogue or mosque was a particularly dangerous thing to do. It was no more dangerous than all the other things people were doing, yet some governments, like New York, were trying to shut it down, right? The facts ultimately matter, and in the first 10 minutes of a pandemic, when no one knows what to do, courts may well lean toward giving the government some deference. But ultimately, when you get the facts in, you can't keep ignoring the facts and shutting down a constitutional liberty. In the vaccine cases, I think we're headed toward a similar thing, which is most states, to the extent they have vaccine mandates at all, have religious exemptions. Even the states that are trying to get people fired for not taking the vaccine, like New York has thousands of hospital workers who have medical exemptions to getting the vaccine. I think it makes perfect sense to say no one should force them to get the vaccine if it's going to give them a terrible reaction. That makes perfect sense. But New York goes a step beyond that. It says you don't have to get the vaccine and come on in and work your regular job and walk around the hospital and do all the stuff you used to do, right? So there's like thousands of people walking around in addition to all the patients, right? Many of whom aren't vaccinated. But New York says if you have a religious objection to it, you have to lose your job. And then on top of that, New York said, and you won't be eligible for unemployment, right? You know, as if they're trying to go back before Smith and try to mess with Sherbert v. Werner and those old unemployment cases. If you're fired for that, New York says we're going to strip your unemployment benefits. I think what we're eventually going to see at the court, Dr. A is now up on a cert petition, what we're eventually going to see at the court is, in due time, they're going to come around to those cases, and they're going to look at them the way they looked at the COVID lockdown cases and Ramirez and Hult and a lot of these other cases and say, well, sure, vaccines in the abstract are the kind of thing the government might have the ability to mandate, but it's going to depend on how well the vaccine works and how big the danger is. And if we can look around and see everybody else is operating in a place where we can have exemptions and not everybody takes it, then you're not going to be able to steamroll religion. Let me stop there.
Great. Thank you, Mark. I mean, it certainly does seem, as we've seen the last couple of years with COVID, that you have a situation which in the early stages of an emergency, everything the government say is credited to a very significant degree by the courts, and then as time goes on, you know, the credibility of those arguments becomes more and more, you know, open to question. Plus, the emergency doesn't seem to be ending, in which case, when emergency becomes a permanent way of life, perhaps the balance shifts. Now, finally, batting cleanup, Mark Stern.
Now that baseball season has begun, we can make those references. Those of you who've ever been present when Nat and I are on the same panel will not be surprised to know that I'm going to disagree with him in, sorry, Elisa, in many particulars. First of all, let me say that both in the first panel and this panel, one has the sense of speaking in an echo chamber. All people who are committed to a particular vision of life, a particular set of commitments. There are a lot of people in the United States, and many of them are, for better or for worse, thought leaders in the United States who have very different visions. So if you talk, for instance, of the religious liberty of the photographer in the Colorado case, in the New Mexico case, and all the other cases that have arisen, you will see in those cases religious liberty claims made by LGBT folk who say, you're imposing your religion on me. You're forcing me to abide by your religious views. If you go to Hobby Lobby, employees say, you're making me live my life the way you want to live your life. That California and New York have made that argument with regard to insurance, although the costs were minimal, and New York could have and California both could have easily picked up the cost of abortion insurance for those who didn't want to pay. But those claims need to be considered. And to talk about religious liberty as if those claims don't exist is to talk to yourself and not persuade the larger culture. How bad is it? The provisions of the Religious Freedom Restoration Act, which passed, if not unanimously, and there may have been one or two negative votes in the 90s, every Democrat in the House has voted to repeal those provisions insofar as they apply to reproductive freedom, health care, and the civil rights laws. Every single Democrat. During the Clinton administration, the president was fully behind the act. His administration pushed it. We would not have gotten it done without them. And now, 30 years later, you can't find a Democrat in the House of Representatives, and I believe in the Senate as well. Maybe you have one or two. But overwhelmingly, if you ever got a bill and you got past 60 in the Senate, you'd lose it in an instant. So it makes some difference. If you go back even to the transcript of the first voucher case, Simmons-Harris, the court never picked up on it, but there were questions. Are these schools allowed to discriminate on the basis of religion and race? If you look at the Boston St. Patrick's Day parade case, the court has a footnote saying this is not based on status of gays. That would be a very different case. I never understood exactly why it would be a very different case in logic, but the court is not prepared to say that you can openly discriminate. The same thing comes up in Hobby Lobby. There's again a footnote saying we're not talking about people losing their jobs because they use contraception. In the oral argument in canon, Kurtzman rather, there was I think it was a somewhat incoherent section of the oral argument, a bunch of questions from justices on both sides of the normal divide that we think of, asking, well, do these schools discriminate on the basis of religion or not? And you know, there are actually lawsuits. I think there's a lawsuit pending in Maryland challenging state aid to parochial schools on the grounds that they discriminate on the basis of religion. This was, if you remember, those of you who have long memories will remember the Points of Light and the volunteer programs that President Bush wanted to fund. The issue that was litigated was these places discriminate on the basis of religion and employment and who they admit, et cetera, or they force people to engage in Bible study as a condition of getting government benefits. I remember speaking to somebody from Americans United. I said, I don't understand. This is when Lemon was still regnant. I said, either the Constitution allows you to fund religious training or it doesn't. But if it does, I don't understand why you can't then be religious. It doesn't make any sense. And they said to me, you're absolutely right, but the media will pick up on the discrimination claim. They don't understand constitutional law. That in large segments of the public, really large segments of the public, look at the Christian Legal Society case, which was, you know, I mean, if the court pretends that case was about educational policy, it's lying to you. That case was about, for the majority, was about, certainly for the school administrators, was about a group that discriminated or wouldn't admit gays or people who supported same-sex marriage. That's what the university was motivated by, no matter what they said in their court papers. And the court said, yeah, you can do that. We're not prepared to allow people to discriminate in their facilities. Now, there are some caveats there if they can't meet elsewhere. The idea of religious liberty is a two-edged sword. There's a statute in Ohio that protects the right of doctors not to participate in medical procedures they find religiously objectionable. It'd be useful to have that in California, for example, but of course you're not going to get that in California. But now it's being invoked by doctors who don't want to care for somebody who's in a vegetative or brain death state, and they say we don't want to, violates our conscience to continue to keep this person alive. I'm not taking a position at the moment on the merits of any of these arguments one way or the other. I do think that to speak about religious liberty as if it were one-sided, if there were no burdens on anybody else, TWA v. Hardison, it's a series of cases. You look at the post office cases involving religious accommodation of employees. It's absolutely impossible to get an accommodation because the union's position is that any accommodation is a breach of their contract. And the courts have so far allowed, I think that's a contract to violate Title VII, which should be void, but the courts have allowed it. When you talk to people in the Postal Service, employees, line employees, they will tell you the only thing a postal employee controls is his seniority. And therefore, if you take that away from me, you make a difficult job impossible. Now, whether that should prevail over religious liberty or not, we could have a discussion about. But you can't have a discussion about religious liberty and focus only on the Sabbath-observing employee and not focus on the cost to somebody else. I say that as one caution. And then, as to the comment that several people made about Shurtleff, Shurtleff is one of a series of cases in which the court has struggled. The Sumim case, the Texas license plate case, where the court has struggled with, okay, this seems harmless. We could allow this, but if we adopt the plaintiff's theory, if we adopt the objector's theory, how does the government keep a swastika or the Klan or all these other hate groups off? Well, you know, one answer is you can't. But the court is not prepared to do that. Even the most conservative members of the court, who would be most sympathetic to religious liberty and free speech in these contexts, are not prepared to require public authorities to display symbols that are broadly accepted as symbols of hate. That's a very dangerous road for us to go down because, after all, the Southern Poverty Law Center thinks lots of people are hate groups because they don't agree with the Southern Poverty Law Center. But the fact is, that's there. It's in the court is struggling with it. And then one last observation about the Coach Kennedy case, which is in a similar vein. Imagine, we know where the political support is, the ideological support is for Coach Kennedy. Imagine that Coach Kennedy had done the same thing as the quarterback, Kaepernick, what's his name?
Kaepernick?
Kaepernick, yeah. Did it in a racial protest. Is the school board required to allow its coach to plunge it into that morass? An argument that it's purely private speech means that the answer is yes. Do school boards want that? Do we really want school boards to be forced to do that? And finally, Kennedy is another case. There's at least some evidence in Kennedy that some team members felt obliged to participate in these supposedly voluntary prayer sessions because they were afraid they'd tick off the coach and they'd get less playing time. Whether that's true or not, whether that's sufficient to outweigh it, we could again debate. It demonstrates that sometimes religious liberty cases have what's good for one person's religious liberty may have real costs for somebody else's. And to speak only about the person who happens to be complaining and not speak about the people who'd be affected is to lead, I think, to a dead end. Anyway, that's enough disagreeing with Nat for one day.
Well, thanks, Mark. And I think this is actually a great pivot point towards opening a discussion among the panelists. I don't know if anyone wants to, Nat, if you want to take up the cudgel, either by podium or otherwise.
Gee, why am I not surprised?
All right. I'll stay at my seat for this exchange. I mean, I came here, as I said, to be able to talk to you about what I think is a misleading impression regarding the Supreme Court and religious liberty. But I had a second motive. And a second motive was to confront Mark Rienzi and Mark Stern. Because I think they are wrong in various ways. Mark Rienzi first, because I have, and I mention in this piece, the Newsweek piece that has been distributed, that I recently filed a petition for certiorari for a group of Jewish congregants who are really disabled and prevented from coming to synagogue on Saturday mornings because there is a group of acknowledged anti-Semites. I mean, there's no question. They say that they are anti-Semitic, and they stand around the synagogue with signs designed to intimidate people who want to come to worship. To me, that is a central liberty under the First Amendment, the right to worship, the right without any interference to be able to go and pray at a house of worship. When I read about a Sixth Circuit decision that said that, no, this is simply sort of Arab-Israeli free speech issue. It isn't, but that's not even the main point. The main point is that an intimidation of the right to worship goes to the heart of the First Amendment. And when I said this to Mark Rienzi, expecting that the Becket Fund would be the first that would support our position, he said, oh no, we are supporting the anti-abortionists who stand up in front of the abortion clinics and they protest, and they have a right to go and protest in front of the abortion clinics. And therefore, it's free speech to stand up at the synagogue and tell the people who are going to worship, no, Jewish power corrupts. Jews should not have any more Holocaust movies. He said to me, free speech controls these cases. Why? Because anti-abortionists should have a right to protest in front of the abortion clinics. And I said to him, the right to worship is one that the founding fathers thought was essential. The right to an abortion may be constitutional today. It may not be constitutional 6 months from now, but it's a very recent development. You have a right to protest, maybe, the abortion clinics, and you want to stand in front of them, but that doesn't give you the right to prevent people from going to worship. That, to me, is an important First Amendment religious liberty issue. And I want today to hear from Mark Rienzi whether the Becket Fund is going to support the Jewish congregants who want to worship at their synagogue and are surrounded by anti-Semites who have prevented people from going into worship. That's Mark Rienzi. With regard to Mark Stern, I'm here today because Mark Stern says, and you heard him say it, gee, there are other people who are affected by religious invocation of religious rights. We have to consider them. Now, 1 minute now. Are other people forced to spend money in order to accommodate the disabled? Do you have to put up ramps in order to make an accommodation for those people who are disabled? What about affirmative action? Are people who may be more qualified pushed off to one side in order to overcome a history of racism? What about those people? Aren't they hurt? No. No. Today's society says we have to do affirmative action. We have to make accommodations for the disabled. But God forbid, if you try to put religious rights as being paramount, Mark Stern will tell you, you haven't taken account of all these other people who are inconvenienced by what is done. I would like to hear Mark Stern address those questions.
All right.
I go
think
first.
there's been a challenge, but we'll start with Mark Rienzi.
I go first.
I would agree with you on the Michigan case.
I go first. I'll give my response briefly to Nat Lewin. I won't do it by doing all the details of our conversation. But I'll say the following. I am deeply sympathetic to the plight of people who have to walk by angry, nasty protesters every time they want to go into worship. I think that's nasty, awful, and wrong. And I think to the extent those protesters intimidate somebody, stop them from going in, block the door, engage in violence, engage in what's legally defined as harassment, I think all those things are enforceable. I don't think the First Amendment protects, in the abortion context or the religion context, somebody who wants to block a door, issue a threat, or engage in violence. So I think all of that is true, and I think Nat's clients are going through something terrible, and I think people should not have to do that to go in to exercise religion. All that said, I think we do have a First Amendment that allows people to engage in peaceful speech. I don't know all the factual details, and if, as Nat says, people are engaged in actual intimidation or threats, I think those have always been prescribable under the First Amendment and would remain so. But I think Chief Judge Sutton's opinion in the Sixth Circuit, at least as I read it, sounded like pretty straightforward First Amendment law. And I don't think that because of a lack of commitment to religious liberty for all. I think that because of a commitment to the First Amendment. I wish Nat well on his cert petition. Maybe he's right. I'd be perfectly happy if those folks didn't have to walk through the gauntlet there. I'd be a little bit concerned about what would be the remaining of our First Amendment if we said, well, if someone's going to engage in a constitutional right, there are going to be limits on how and how much you speak outside of it, right? So what would it do to protests outside of the press or protests outside of other protected activities. And I'm with Nat. I don't think abortion is a constitutional right on par with religious liberty. It's not. It's something the court made up. I hope in Dobbs they get rid of it. But at the end of the day, we have constitutional rights like that, and we have some judges who would be downright eager to say, when someone's exercising that constitutional right, Eleanor McCullen, who was my client in the abortion case Nat mentioned, shouldn't be allowed to stand outside that abortion clinic and offer women help. You know, I think, and I fought very hard to say, Eleanor McCullen has the right to stand on the sidewalk and to offer help and assistance, even if the clinics say women don't want it, even if no one wants to hear it, even if it is a constitutional right, which again, I don't think it should be. Ultimately, I think people do have the right to disagree. So if it's intimidation, if it's violence, if it's obstruction, if it interferes with your ability to have your religious ceremony inside, I think all of those things are prescribable and should be prescribed in many circumstances. But I also think the court is not likely to say that you can't stand outside and peacefully say something ugly and nasty. Unfortunately, the First Amendment protects people's rights to say ugly, nasty stuff.
Thanks, Mark. Mark Stern, you're...
One fun sidelight, and I think Mark's analysis is entirely correct in the synagogue case. And factually, as far as I understand it, the Ann Arbor police were perfectly willing to ensure that you could get access to the building. You simply had to undergo the unpleasantness. In general, I think that's something we need to learn in our First Amendment activities nowadays. It's under broad enough challenge and is in our universities, where the argument is, an argument makes me uncomfortable, you shouldn't have the right to say it. So I think it's a fairly dangerous road to go on. But the fun fact about that case is, for years, the synagogue had a fundraising project. There would be a betting pool every week as to how many protesters would be outside the synagogue. And they made a fair amount of money that way until somebody finally got fed up and decided enough was enough. Anyway. First of all, that misquotes me a little bit. I did not say, deliberately did not say, that the claims of others trump. I said they need to be considered. And the strength of those claims is going to vary. My own view, for years when I was in the American Jewish Congress, I was able to assert this publicly, is that if there's another photographer down the block or another pharmacy down the block where you can get the Plan B, then you shouldn't force this pharmacy or this photographer to do it. If there's no other pharmacy or no other photographer, then that's a different case because the rights balance differently. All I said is that you need to consider both sets of interests. I think as well in this culture, and I adhere to this view, the non-discrimination principle is now so strongly held and so unchallengeable that you need to think very carefully before you go up and fight it. It doesn't mean you shouldn't. It doesn't mean that the Equal Protection Clause is the only clause in the Constitution. It's a mistake many make. Many law professors start from that assumption. Somehow the Equal Protection Clause de facto overruled the Free Exercise Clause. But to act and to speak as if those trends did not exist in society, and even the conservative members of the court who've been sympathetic to religious liberty have been very careful not to attack that principle head on so far. They've carved it out. They've walked away from it. It is an indication that people need to be listening to. And one last anecdote from the days, I don't remember if it was in connection with RFRA or Arlupa. They merge in my mind. But in one of them, we had the statute drafted, and then, I guess it was OLC, sends it around to all the agencies in government, comment on this draft. The president would like to endorse it. Tell us how it's going to affect your agency. And all sorts of stuff popped up that in a million years we never would have dreamed about. What do we know what goes on in the Bureau of Land Management in Montana? We have no idea. And we sharpened the bill as a result of those comments. There are things that we weren't essential, we dropped them. Things we made the language clear. My point is that it's a very big country, it's a very complex country, there are lots of views, And I think there's a lot to be said for the Supreme Court. It would have been nice if Employment Division versus Smith had never been decided, right? I thought it was wrong at the time. I did petition for a hearing. I still think it's wrong. Having said that, we are where we are 30 years down the road. Culture has changed. There's a lot to be said for proceeding carefully, because if you get a decision that's hugely unpopular in large parts of the country, it may not have legs. This is a mistake, frankly, I watched from inside a liberal organization as an early supporter of abortion rights in the 60s yet. But we watched with amazement at pro-choice groups simply doing nothing but point to the Supreme Court decision. They let the pro-life groups organize, they let them mobilize public opinion, and all that those groups would do was say, excuse me, Roe v. Wade. They made no attempt to marshal public opinion, to do the hard legislative work. They simply rested on a Supreme Court decision. So even if Employment Division versus Smith is overturned tomorrow, you could have, Congress could challenge it in dozens of ways. The funding, for example, any number of ways. So you need to pay attention to the culture in which you're working, and not just the people who share your views, but people who feel differently. And just take that into account as you map your strategies and you formulate your arguments and you pick your cases.
Thank you. I think what we've discovered is that 75 minutes is actually not enough time to discuss in any detail these issues, much less to get to any active discussion about some of the cases pending before the court, which, I would predict that these issues will not be resolved at the end of this term.
And that my own theory on why the court takes religious liberty cases. They always have, even in less political time, because they beat bankruptcy code and tax code cases.
There is no quick. Well, I mean, since we're out of time, but my thought on Nat's comments about sort of the picayune nature of these cases is, one, this is not new, of course, right? I mean, part of it for logical reasons. Religious majorities don't need the protection of the courts, and so religious minorities are most likely to find themselves on the losing side of government programs, whether it's Jehovah's Witnesses, whether it's the Church of Babalu Lukamai, or whether it's, there you go, or Native American peyote users as well. And then incrementalism, of course, is something that we've seen in a variety of contexts, but how long it lasts and kind of where the court goes with, the current court is, I think something that we'll see maybe as soon as June. But unfortunately, we ran out of time for questions for the audience, but it's really a great discussion, and so thank the panelists and for the